Good evening, everyone. I'm Reverend Jeanette Wilson. I'm Senior Advisor to Reverend Jesse Jackson of the Rainbow Push Coalition and National Executive Director of Push for Excellence and Senior Pastor of the Maple Park United Methodist Church. I am so excited to bring this particular session to you, the question about this new Illinois criminal reform law that is really called properly SAFETY Act. That means Safety, Accountability, Fairness, Equity Today Act. And we have some powerful people who will be able to share some tremendous insight. Many of us heard about this new act, this new law. We don't know what's in it. We don't know how it impacts each one of us. And so we wanted to bring to you the experts that could share correct information. You don't have to figure it out. We're going to tell you about it tonight. Before we do that, I want to thank all of our presenters for this session. We have the Rainbow Push Coalition, we have the NAACP, DuPage County, and Patrick Watson is here representing DuPage County NAACP. We have NOW Illinois, represented by Laura Welch, and the National Association of Jewish Women, represented by Jan Schwartz, who's worked harder than any of us to make this happen. Plus the 44 co-sponsors that you saw on the two screens earlier. This is a real collaborative effort to make sure that all of us are aware of this new law and aware of what it really means to communities, to individuals in the state of Illinois. We will make sure that we answer your questions if you put them in the chat, and we will answer your questions before the end of this session. We want to make sure that you get some information on the front side before you start asking questions, just to make sure that we can answer questions that have not been answered by one of the speakers. We are going to open with, I am just so pleased, and as they said in the church years ago, I'm peacock proud to, to meet the new Speaker of the Illinois House of Representatives. The new speaker is Speaker Welch, who is going to share with us what this new law, well, really the evolution of this law and really what it means to us. Thank you and for coming tonight and sharing. Thank you, thank you, thank you.
Well, thank you, Dr. Wilson. Good evening, and thank you all for having me here tonight. I want to thank you and to Rainbow Push, the NCJW, the League of Women Voters, the NAACP, Chicago Women Take Action, Independent Voters, and all the organizations who put this important event together tonight. I want to welcome the panelists, especially my friend and our great state's attorney, Kim Fox, my new friend and our new fabulous public defender, Sharone Mitchell, and all of our panelists for this discussion that we're about to have tonight about our justice system. It's important that we get the correct information out there. But before we get started, though, I want to emphasize one thing. How we think about and address issues facing us as a state will be a bit different now that we have Black people in leadership across Illinois at all levels of government. And for the first time in the 203-year history of this state, we have a Black lawmaker as Speaker of the House. We should not be shy about that, particularly as we embark on what's likely to be the most consequential years of our service in state government. Now, of course, pro-Black does not mean anti-everyone else. That is a false narrative. Black prosperity is not a threat. In fact, it's the only way we reach our full potential as a state and as a country. But if we are honest, we have to admit that the deep challenges we face, from the pandemic to economic growth, police reform, and education, are all rooted in racial disparities that have existed long before today's crisis. We need bold change, but that change needs to be anchored by a deep sense of equity and justice for all, but particularly for Black and brown people. To that point, last year, the Illinois Legislative Black Caucus unveiled 4 priority pillars to lift up and better protect Black people, Black families, and Black communities. One of those pillars focused on criminal justice reform. Our state's attorney will tell you it's been needed, and it's been needed for a long time, and we finally got something done. While the Illinois Legislative Black Caucus unveiled these pillars in the wake of George Floyd's murder, make no mistake, these priorities have been years, if not generations, in the making. Now, here's what the bill does. Here's what the bill does. It replaces the existing flawed cash bail system, which results in people with money getting released into the community and those without the monetary means being forced to stay in jail, regardless of the threat of either of them present to the community. Not only does this diminish the racial disparities we see with cash bail, it also ensures that dangerous people actually stay behind bars, regardless of how much money they have access to. The law improves officer training, especially in the areas of mental health and de-escalation, and strengthens certification standards. It requires body cameras to protect both the public and the officer. Think about that. Thank God we have body cameras now, because we're able to see what's going on out there in those streets. And it limits the use of force, like banning chokeholds, like putting someone's knee on your neck. It also calls for a task force to further review issues of constitutional rights and legal remedies, such as qualified immunity. The goal of the task force is to produce a report that clearly outlines how we can better hold police accountable. I know for all of us on this meeting tonight, the pain can cut deep. We are tired of having to deal with a flawed, unjust system. But change happens at the speed of relationship. So I hope we can work together in the coming months and years to get this right. Change wasn't fast enough to save George Floyd, or Trayvon Martin, or Rekia Boyd, or Laquan McDonald, or Adam Toledo. But if we remain hopeful and continue to do the work, change can save another person's life or livelihood, and it can certainly save our communities across this great state. I hope you all have a fruitful discussion tonight, and I thank you for having me. And I got to tell you, you're in for a treat with this panel, folks. And enjoy, and again, thank you for having me.
Well, thank you, Speaker Welch. That's a great springboard into looking at the elements of this new law, the SAFE-T Act, SAFE acronym -T, SAFE-T Act. And I keep repeating it because we need to know the name of the law. It is no longer a bill, it is the law. And now we're going to get into what's contained in the legislation, and want to go to State's Attorney for Cook County. I think one of the most powerful state's attorneys in this country, mainly because she's my state's attorney in Cook County, but I've seen the leadership that she's provided, the kind of expertise, and she's taken some tough positions in a tough season in this city. And so, Attorney Fox, what does this law do for us? And what is the process and time frame for implementation as you see it?
Well, first of all, Dr. Wilson, thank you so much, and to all of the host organizations for pulling this together. As you said, this is a monumental piece of legislation that was, quite honestly, years in the making. And I'm really proud and honored that the other panelists on this call I've had the opportunity to work with over the years around issues of justice reform. John Mackey and I go back to his days at the John Howard Association and his work there. And then again, addressing, when he worked with the state, the disparities in our jails and prisons and the over incarceration rates. Sharone Mitchell and I are now contemporaries, but his work and advocacy as an advocate on criminal justice reform has been well documented, and his efforts to get this bill across the finish line cannot be understated. I'm also really proud to have in the state a new state's attorney in our association who shares progressive values and a steadfast commitment to justice and equity in State's Attorney RINEHART out of Lake County. It has been a lonely place in the state in advocating for a lot of these issues because whilst Cook County is large and mighty, we are but one voice. And so the advocacy of State's Attorney RINEHART, who was truly just weeks into office when he rolled up his sleeves and got to work on this bill to help it through the finish line, also can't be understated. And so it's really an honor and a privilege to be here tonight. And again, thank you to Jan and Patrick for pulling this all together as well. The significance of this, around bail reform really must be highlighted. And I think one of the things when you talk about a tough position that I often find myself in is around the notion of safety, not the acronym, but the truth. And for so many people, they have been taught that safety is equated with the system that we have right now of cash bail. That when someone who commits a crime and is arrested or is alleged to have committed a crime, is arrested and charged, they are, still presumed innocent until proven guilty in a court of law. Many people believe that bail is somehow a pretrial punishment. It's not. The purpose of bail was to ensure that people return to court for their court date, that they don't flee, and if they were a threat to the public, then there should be conditions that have been applied. But what has happened over the years is that we've eliminated kind of this notion of is someone a threat and how we assess that threat, and really made the triggers of whether someone is free or locked up based on cash, the availability of money. And that notion that people who are somehow more accessible to money are less dangerous, while there are people who don't have access to cash who languish in jail pre-trial. This is even before COVID, which has slowed down the courts tremendously, who would languish in jail for weeks, months, and sometimes years simply because they could not afford their bail. And the things that we don't talk about with that are that people who are languishing because they can't afford are often then put into predicaments where they're having to decide whether I'm going to plead guilty to a crime that the state has not yet proven, just so I can go home, so I can be free. The other thing that we don't talk about is that, yes, there are people who've been charged with first-degree murder who've been able to pay their way out of jail in a wait trial. We had murderers, or now convicted murderers. I use Jason Van Dyke, for example, the police officer who killed Laquan McDonald. Jason Van Dyke waited for his trial at home because he was able to pay his bail. Meanwhile, we had people sitting in jail charged with retail theft who couldn't afford something as little as $500 getting out. And so what this bill aims to do, particularly around bail, is remove cash as the determinant of who is free and who is not, and to have a real assessment on, is someone a risk to public safety, and have a default that people are not detained unless there is a finding of dangerousness that has been proven. And not just, because the state says so, but because we've presented evidence to show that someone is a threat to a community or a specified person. And so this bill fundamentally changes how we look at pretrial detention, how we assess risk, and eliminates the false notion that access to cash is a determinant of whether someone poses a risk to public safety. And I'm incredibly proud of this. Illinois is the first state in the country to legislate the elimination of cash bail, with the recognition that our system has been so fundamentally flawed for many, many years.
So I think this will set a model for the country as we talk about this idea of not making bail a system between the rich and the poor, because that's really what it was. And having practiced criminal defense law for a number of years, you realize the people that can generate the most cash are always on the street. And the others, they just sit, as State's Attorney Fox said, they just sit in jail for years. We have a number of people who could not make bail. They've been in jail 7 years, merely because they could not pay the bail. And that's unfair. And it really speaks to poverty. And I know all of the attorneys on here understand that and know that. And I know Eric RINEHART, he's been waiting to to share. What do you see as the, I know you agree with Attorney Fox about the cash bail. How is it safer for us as a community? Many people think that if we let them out on bail, the whole society is just, we're all gonna have to walk around with guns and worry about our own individual safety. What do you say about that?
Well, yeah. Well, first of all, I want to thank everyone. I want to thank the sponsors, particularly the Rainbow Push Coalition and the NAACP. Thank you so much. Speaker Welch, I think, articulated the issues in this act so effectively, and State's Attorney Fox really talked about the sort of underpinnings of why was this reform necessary when we look at, as you said, Dr. Wilson, why is it that we use wealth? Why is it that we use access to a 401k to decide whether somebody should be in or out? But I see that Mr. Mackey is here, and I know that his organizations have advocated for this. I think about the victims and the survivors groups that have advocated for this. And that's, I think, one of the more disappointing parts of the debate and the fiction that has come up out of this discussion of this bill. Debate is good, discussion is good, but let's at least be debating and discussing the real parts of the bill and not these parts of the bill that suggest that somehow victims are hurt by this. I've still yet to hear the argument as to why not using cash somehow threatens victims by judges looking at whether somebody is dangerous and having to articulate that, which is what the federal system has used since the mid-'80s, which is what other states have used. And as you said, Dr. Wilson, we can be a model for the rest of the country because we're going slow. Many of us here have already started talking to the Supreme Court and the AIOC about how to administer this law because we still have 2 years before it's put into place. It makes us safer.
So hold on. So yeah. This law does not take effect until 2020 what?
2023.
2023. So
for those of 2023.
Okay, I'm sorry. Go ahead.
No, that's okay. No, that's okay. So we have time to work with our partners in the courts, our partners in the sheriffs with the jails, with the clerk's office. That's very important too, to get all of this right. We have plenty of time, and that's, I think, one of the genius of the bill. Perhaps Mr. Mitchell can speak more to that, or Speaker Welch. But the bill is fantastic, and I want to thank the Black Caucus for their foresight to say, let's take some time to get this right. I think other states may not have done that. This bill makes us safer because it has judges articulate whether or not somebody is safe or not. That type of information forcing rule, that transparency is a really critical part of why I support this bill, because everything else has just been veiled in numbers. And the example I always get is well, so my carjack, there's a lot of carjackings in Chicago. I know it's a serious problem that State's Attorney Fox has been working so hard on. And people say, oh, so the carjacker won't have a bail. Why would people assume that? Why wouldn't people just assume that the carjacker would be held without a bail? So the question I would say back to people who say they want cash bail is, how do you know your carjacker's aunt or uncle or friend doesn't have $7,500? That's the question that nobody has been able to answer as they have argued against the bill. There's an assumption that dangerous people will be out of custody. I believe that everything we've seen is that the bill would have dangerous people be in custody and not be able to use access to cash to get out of custody. So there's so many reasons I support the bill. I support the bill because the Illinois Coalition Against Domestic Violence supports the bill. I believe it's I can't remember the name of the organization. One of the preeminent Chicago organizations against domestic violence supports it. Two of the most historical voices for the survivors of domestic violence support this bill, and that's one of the many reasons that I do too.
Well, on this whole idea of who gets out of jail on bail, so now the bail will be based on what? It's not based on the ability to get cash. What criteria will be used according to this law for those who seek to be released on bond?
Well, I'm happy to answer. I don't know if anybody else wants to jump in, but the courts are going to be looking at a variety of factors. They're going to be looking at somebody's connections to the community in terms of whether they would flee. They'll be looking at somebody's criminal background, what they've done in the past. They'll be looking at the nature of the offense. They'll be looking at how they've performed on bail before. They'll be looking at how they've performed on probation before. None of these factors are unique, though. These are all the factors that the judges say they look at now. It's just they express the answer in money. So they say they look at those factors, and then the money, the ruling is expressed in dollars and cents. That doesn't make sense. This bill changes that.
Well, I want to hear from, since we've had two state's attorneys, two prosecutors, I want to hear what you have to say, Attorney Sharone Mitchell. You're the new public defender for Cook County. You have the burden of being the one defense attorney on this panel. So Speaker Welch has left you here alone.
Okay.
Tell us.
Listen, us public defenders are used to being alone and fighting for justice.
I know.
Sometimes it's a lonely road, but we get through it. Yeah.
And they have, and the state's attorneys have double the resources than you have.
Yeah, we'll talk about that. We'll talk about having 4% of the county budget in a second. But with that said, thank you all so much for having me. My name is Sharone Mitchell Jr. As you heard, I'm the Cook County public defender. Thank you to all the groups that put this thing together. I think this is going to be a really great discussion. Speaker Welch, he's led this state with such grace and wisdom. He has not been in office very long as speaker, but you've seen the results with the 4 pillars being passed. I do think it's a new day in this state. John Mackey is going to talk here soon. He's been a champion both inside and outside government. And then, a lot of people call them progressive prosecutors. I'm just going to call them honest prosecutors, right? Because we have a problem in our justice system. And I think the 2 prosecutors you have on camera right now are honest about the shortcomings of the justice system and are willing to make a difference. So you can call them progressive, I'll call them honest. Certainly prosecutors and defense attorneys will go back and forth. Our attorneys will be battling, but I'm so happy to have these 2 as champions when it comes to policy. There are things that we can agree on because everybody knows the current system is not working as it's supposed to. So we talked about me being new. 30 days ago, I wasn't a public defender. I was an advocate. I worked for an organization called the Illinois Justice Project, and I was so proud to be part of a coalition. It's a coalition to end money bond and the Illinois Network for Pretrial Justice. And these folks, these are grassroots organizers. These are service providers. These are legislators. These are leaders of the faith community that have been fighting to not only end money bond, right, but in or reduce inappropriate pretrial incarceration. The dirty little secret is and this is the first thing to remember. We're talking about people who are accused of crime, right? These are people who are accused of offenses, right? So sometimes we kind of conflate this idea between somebody being arrested and somebody being guilty. And I think that's really difficult to think about, knowing that we are in a state. Let's just take a couple examples. When we ended the death penalty, we had exonerated more people than we had executed, right? We live in a state where there are at least a county where at least a quarter of people will be released after they're arrested because the evidence wasn't there, or they were found not guilty by their peers. They were found not guilty by a judge. So sometimes we have this kind of reaction that, if you're arrested, you're guilty, and nothing in our system suggests that. So innocent until proven guilty is sometimes think of as an old kind of dusty legal theory, right? But it's real. It's a real thing, and we see it every day. So the Coalition in Money Bond, Illinois Network for Pretrial Justice have been working on kind of changing the system. And they did it through the end of money bond. But I think we'd be making a mistake if we just thought about it as the end of money bond. This is a entire recalculation of the system. When somebody's arrested, they go before a judge. And the judge has to make a decision about what's going to happen to them before trial, right? And the judge in the certain status quo really has three decisions. The judge can decide to hold the person can't get out. The judge can decide to essentially release the person. The case isn't over, right? But they're on their own to come back and forth to court. Or the judge can kind of do this weird third thing, which is say you're eligible, right, for release, but you've got to pay a certain amount of money to get out. That really launders the decision about whether somebody's going to be in or out to how much money that they have. And we know that the reality is that poor people get stuck in jail. And that's terrible, right? But we also know that has a real impact on the entire system. So people who are stuck in jail are more likely to plead guilty, and they're more likely to serve longer sentences. And we know in other states, there have been studies that suggest that Black folks and brown folks are more likely to get higher bonds than their white counterparts, right? Studies from California. So what we're doing here is that we are removing money as the determining factor in whether somebody should be in or out of jail, and we're creating a better set of circumstances. Now, again, our belief is that this will reduce the amount of people that will be detained, but as my prosecutor friends have talked about, this will, there's an argument that this will give people in a better position to detain the people that we want to detain as a society. But so I look at this thing in four parts. The first part is that it ends cash bond, and I think I have to talk about how who's paying the cash bonds now. Don't go there now because we're in the middle of a pandemic. But if you went to where we bond people out in Cook County, see who the people are bonding people out. It is Black women, it is mothers, it is grandmothers, it is sisters, and it's the Black church. There's a study from Loyola University that talked about $31 million have been taken out of Cook County in a 6-month span. Is a tax on the Black woman. That's what cash bond is. Secondly, it changes the system for determining who's in jail and who's out of jail. Right now, we're working with a statute that conflicts all over the place, and there's not a clear process for actually making determinations. They happen in 30 seconds, snap decisions about whether you're in or out of jail, and this system improves that. And it also addresses a number of legal structures, like how we do warrants, cite and release. It adds lots of little things to the system. And then finally, and I'll shut up after this.
Yeah, you might have to, because I got to go to somebody else. We're coming back to you.
One more piece. It collects data. I'm sorry. Don't let the public finish talk.
No, I shouldn't let any of you lawyers talk. I'm going to go. I'm going to leave lawyers in a minute. Go ahead. Okay.
It collects data. We don't know what's going on in our system, and it actually collects data. So we know in all 102 counties what's happening in bond court. I'm going to go on mute now. I apologize.
No, you don't have to apologize. That's what lawyers do. They talk. So now we want to go to someone who's been studying this. He's not a prosecutor. He's not a defense attorney. He has been in the community, director of Innovation Alliance, right? Innovation Alliance for Safety and Justice.
Right? Alliance for Safety and Justice.
Alliance for Safety and Justice. Aren't you the director? John Mackey?
The Director of Innovations, correct. Yeah.
Yeah, Director of Innovations, which is a lot. So you have to now tell us, what does this law say other than what they've already said? We know that it impacts cash bail. What do you see in terms of police training and the other things that this law impacts? And from your perspective, coming from the community research kind of perspective, tell us what you see.
Absolutely. Well, first, let me thank you and the sponsors for inviting me here. It's a real honor to be amongst people many who I've known for many, many years. State's Attorney Fox, Public Defender Mitchell, really honored to see you in your positions. State's Attorney RINEHART, really admire the work you're doing in Lake County. And of course, Speaker Welch, amazing to see his ascension. as well. So actually what I want to talk about, in this bill, there's this kind of a question mark, well, what about the victims? This bill actually has one of the more substantial victim service reforms Illinois has done in many, many years. It's around a program called Crime Victim Compensation. Now, this is probably a program that you don't know about. I've worked in criminal justice for 15 years or so. I didn't really know about it until a few years ago. And let me give some brief highlights about it. I want to talk about why it's important and what the law does to make it better. So as I noted, this is an entitlement program, which means you are entitled to it if you meet the conditions. It's for victims of violent crime. In our state, it's co-administered by the Attorney General and the Secretary of State. All states and territories have a program like this. It is partially federally funded and funded by state dollars. It is built to be a payer of last resort for victims of violent crime for services like funeral, medical costs, lost wages.
Counseling.
And so, absolutely. And so, in terms of like the community's response and like, what about the victims? This is a program that I first learned about. I don't know, Sharone, if you remember me talking about this early on. I learned about it from parents who's lost children to gun violence. And I kept hearing stories about how parents were told about a program that would help pay for their funeral of their loved one. The program never quite worked. They would go into collection. And these were honestly, I'd worked in wrongful convictions. I'd worked around prison conditions. These were stories that were some of the most heartbreaking stories of injustice that I've ever heard. And actually, I started looking into it, hoping they weren't true. But they were true. And what I learned about this program is that, Illinois' program at the time, horrible, certainly was not one of the worst. But even though this program, in many ways, it's a beautiful thing. It's set up for the government to help meet people at their worst moment, right? When they need things like to help the resources to bury their child. And instead, what this program does, it would re-victimize people. It would re-traumatize people. It would exclude the very people that are the most victimized and least served in our society. And in particular, in Illinois, in law, we had several statutory barriers to services. One is that we were a handful, and I say we because this has all changed. So there's some good news at the end of this. We were one of a handful of states, only a small handful, that would exclude people from compensation if you were on probation or you were on parole. Right. In other words, if you were on parole and probation, you couldn't be a victim according to the state of Illinois under this law. We also know people in those conditions are often some of the most victimized. They are incredibly vulnerable. It would also, this is very common throughout the country, it would bar people who are found to be responsible for their own victimization. This is sometimes called contributory harm. And so, on some of this level, it makes sense, right? If you somehow do something, like if you go rob someone and you get hurt in that process, you're not quite a victim, right? And so some of that makes a little bit intuitive sense. The way it would play out, though, is that it's basically blaming the victim. And the way it would play out as well, you were a gang member. Everyone knows you were a gang member. Therefore, you weren't a victim, right? And what did that mean? Well, maybe the police thought you were, maybe that was just how you looked. So it invited all kind of discrimination. And again, blaming the victim for their injuries. It could also deny people for not cooperating. Now, this I think is a really pernicious thing that there's no, so essentially what this program would do, it would try to coerce people into cooperating, meaning, okay, you want to bury your child, well, you got to help us first. That's cruel on its face. There's also absolutely no evidence whatsoever that kind of coercion, the coercion into service, makes people want to work with law enforcement at all, right? Common sense would say that's going to make people really distrust law enforcement. It doesn't work. But finally, this program, and this is very consistent across the country, it would take sometimes years and years and years. So again, this is a payer of last resort, people who have no money, people who need money to bury their child, to get medical, to pay for medical services. It would take years for their claims to be processed. And so it was so poor, it would never actually work. So the amazing thing that this law, so I think first of all, we have a new AG Raul. He has taken this program on. He's the only attorney general I know who's actually made this an issue. He made an issue in his campaign. He's restaffed his agency in this way. So he's doing amazing administrative stuff. At the same time, and I'll like Sharone, I'll be quiet in a moment here. This bill has done some really important things statutorily.
I thought because you weren't a lawyer that you were going to.
No, I am a lawyer. I have to say that was your problem.
Oh man,
I'm not a good lawyer though. So that's
No, you're a great lawyer. I can see because you're arguing
I'm the
your
last.
case.
Yeah. Let me just say quickly what it
Oh
does.
my goodness.
It's really fast. So this bill, one, it expands. So this bill had kind of a very, very traditional understanding of what a family member was. Only a family member could get services. We know, families come in all shapes and sizes. So anyone who has a family-like relationship can access these services. It also finally, it takes the bar away from being on probation or parole. It establishes a quicker review process, right? So you're not spending years and years and years waiting for your claim to be processed. It shortens the time of actual review. It eliminates that idea of being responsible for your own victimization. And finally, it modifies the cooperation requirement. So you don't have to cooperate, or at least sometimes even like you would be kicked out of for not cooperating based on law enforcement might say, well, he told us something, but we knew this guy knew more. So that's now been modified. So this has now gone, I think, from one of the not the very worst programs, unfortunately, and there's actually worse programs in this, but it's gone from probably like the lower middle range of worse to, I think, actually on paper, one of the best programs.
I thank you for really getting into the Illinois Crime Victims Compensation Act. Many people were unaware of it. I found out about it working for CPS because so many parents were losing children as a result of gun violence or violent acts. And children were dying. Parents didn't have insurance. They could not bury their loved ones. And so that was in Paul Vallis's administration. He began to met with the then Illinois Attorney General. And so for those of you who are watching, if this bill expedites access to those funds, and the big deal was, as you said, Attorney Mackey, sat there quiet, didn't tell me, Attorney Mackey, that if you were a victim of a crime, but you also had a record, you could not access the Compensation Act, which is crazy. I mean, your family could not, because you were then almost perceived as a perpetrator. So now this law also deals with some requirements for police training. In Illinois, many police districts around the country, and all of you can answer this, we know that training of police officers is an issue. It's a major issue. So how does this law change the training, and does it require police officers to receive any counseling, R&R? Like if you go to the military and you go to war, you have to go back through R&R when you return return home. Does this law help in any way to deal with the PTSD officers have? And does it have anything to do with training? State's attorneys, public defender, Mackey, attorney. Okay, I'm gonna call you out one by one. Who can talk about police training? I'm gonna start with Attorney Fox in the bill, in the law.
Yeah, there is provisions within the bill that mandates training around de-escalation techniques. And when we say de-escalation, what we know is that far too many police officers are called out to situations that many of them deal with people who are in a state of crisis, whether that's a mental health crisis or a substance use crisis, not necessarily an issue of safety. And as we have seen, unfortunately, far too often, that these circumstances and these encounters can oftentimes turn deadly as a result of that type of intervention. And so what this bill or what this law now mandates is that there is kind of uniformity in the types of training that we have for officers across the state, particularly highlighting the work on de-escalation, meaning how to engage and interact with someone who may be in a state of crises without having to resort to the use of force, any use of force in order to maintain that situation. And saying, again, looking at the types of, if things do escalate, the types of restraints and holds that people can use, again, in light of what happened, brought to light with George Floyd, with chokeholds, again, having some mandates of when that type of force and what force looks like in those circumstances. So there's a de-escalation component, and again, some uniformity around use of force standards.
And now, does the law require the police to send someone other than an officer to the scene where the operator knows it's not a situation where the person is a danger to anyone other than themselves in many instances, because they're known to have a pre-existing mental condition? Because we've seen 3 people. I remember this kid out in the south suburbs at home with his parents, and he was having an episode. I think he was not autistic.
He was on the spectrum. I know what you're talking about.
On the spectrum, Stefan Watts. Stefan Watts was on the spectrum. And if you corner someone who's autistic, that creates another kind of anxiety. Does the law deal with any of that?
No,
State Attorney RINEHART, I can feel you wanting to say something.
No, well, it certainly increases the training for officers. The bill is relatively specific about the curriculum that officers receive. And also, to answer your earlier question, and I think we're all sort of thinking about how to talk about these different pieces. There's also increased resources for evaluations and counseling of officers. It encourages to get assistance to our officers, many of whom, almost all of whom, right, are working so hard to protect us. And what this bill does, I think, and really what all of criminal justice reform does, is it recognizes the humanity on all sides of the equation. It recognizes the humanity of the person who's suffering from substance abuse disorder. It encourages officers and all of us in the justice system to think about the humanity of somebody who is suffering from a mental health crisis. And so this bill doesn't mandate that counties send alternative first responders, as you were asking about, but it encourages police officers to learn about the mental health crises and the mental health disorders of the people that they may be responding to. Criminal justice reform and all of improving all of society is a slow process. But what this act does is it finally starts us down the road on some roads that we hadn't started down yet. So this bill doesn't fix everything overnight, and nor do the people who worked so hard on it claim that it does. But there were a lot of areas of criminal justice reform where we hadn't even started the process. This requires body cameras for all officers. We should have required that in 2015. If we had required that in 2015, in Lake County anyway, we'd have a lot less questions right now about certain officer-involved incidents. I had to sit with a family who had lost a loved one in police custody, and the body cameras don't show us everything we need to know. But I can't imagine doing it without body cameras. So this bill does so much to bring transparency to our system, and it is really common sense.
Okay, I'm looking at questions from we have 430 people that are watching us on this Zoom platform, and we have another several hundred on Facebook and YouTube. First question, if someone is arrested with a gun-related crime, are these people going to be considered dangerous and stay in jail until trial? Yes, no, maybe.
The bill doesn't say, if it is this case, then you will be held without bail. As was mentioned earlier, there are factors that judges will have to determine and make, a written finding of why someone will be held. So the gun is one aspect of it. What is the offense that you committed with that gun? Were you someone who was committing a carjacking? Were you someone who had robbed someone? Were you someone who got pulled over and you had a gun on you? So again, it depends on the nature of the offense. They'll also look at what your background was. Have you been arrested or convicted of having a gun previously? What is your criminal history look like? And then there is also a risk assessment tool that is utilized in Cook County that will be utilized in other jurisdictions that will be able to inform the judge of what is your likelihood to re-offend while out or to offend while out. Again, remembering that the presumption is that they have not been, or that they are innocent until proven guilty. So those are the factors that have to be considered by a judge. And so it's not a yes, no answer. All of those things must be, a determination must be made by a judge to determine whether or not someone will be held or not.
Does the law do anything about accountability of judges? Yes, no?
Yes, that's,
Okay.
yes. Because let's use your questioner's question. The questioner asked a great question. State's Attorney Fox talked about all of the factors that would go into it. So instead of the judge saying the words $4,000 or $40,000 and moving
30
on
seconds.
to the next case, he or she has to give an answer about confinement, about detention. So it's a fantastic system. And I think what so many people don't quite understand is that judges are already making all of these decisions. And so I would say back to the questioner, and this is why I would love to have an in-person event, I'd say, I don't know the answer, but I'm really sure I don't want the judge to answer the question with a number. That's the problem. Right now, the judge answers the question with a number. The judge doesn't say, you shall be confined, you shall not be confined. The judge says a number, which leads to the entire uncertainty about access to money. That's what this bill eliminates.
Well, and I think the other thing is you have some factors that will be a part of judicial training. Judges go to training as well. Right now, the training that they attend does not give them specific guidelines for cash bail. It gives them guidelines for bail.
They have guidelines. They're factors that they're supposed to be looking at. And I think, again, since Sharone is, or Attorney Mitchell is deemed as truth tellers, I think we have to tell the truth here, is that a lot of this isn't new, right? The Constitution, in fact, is enshrined in the Constitution Bill of Rights that you have to not have excessive fines, fees, bail. The other piece is all of these factors that we're talking about that you're looking at, is statutory already. What has happened though, is that for that person who has a gun and you have to give a reasonable bail, what a lot of judges have done is I'm going to set a $100,000 bond, knowing that this person doesn't have access to the $10,000 it costs to get out. And so that has been one of the ways that people have attempted, or judges have attempted to hold people, are setting monetary amounts that they actually know people cannot afford. And so that's one of the mechanisms to be able to hold folks. And I think we have to be careful, again, in looking for, and I've seen a lot of this for people who are in opposition to the bill, of saying, well, this person won't get held, this person will get out. It really is requiring judges. And I can't go on any panel without reminding people it is judges right now who make a determination of someone's ability to be detained or set free and set conditions. It's not prosecutors, it's not defense attorneys, it's judges. And having to have them make a record for why they are making that determination is more transparent, and the accountability that we are often seeking from people in the justice system.
So you're saying at least they're going to have to put in their release on bail a reason why this person is released without bail, without money. But Mitchell?
Yeah, I think State's Attorney RINEHART and State's Attorney Fox are correct, right? When we're talking about, judges' accountability, when a judge sets a bond, at that point, we don't have a clear answer whether somebody is going to be in or going to be out. And, one of the reasons why many of the domestic violence groups are very anti-cash bond is that very same reason, right? This idea that somebody can bond out at any time. Now, let's be clear, just detaining somebody is not the solution in many instances, right? But if we are concerned with somebody's kind of safety, a bond system, which allows somebody to bond out, isn't the best way of making determinations about who should be in and who should be out. And the result of that system, there are far greater percentage of people who could be released safely, but are stuck in jail because they don't have the money.
And then you have a lot of the people that are more violent released because they can make the bail. I get it. Another question is the officer training. You say it's been improved. Will the law ensure consistency across police academies, departments? Are there guidelines for who will facilitate the training? And how often do the police officers, are they going to be required? Like all of lawyers, we have to take continuing legal education. Will the police officers have to be trained on a more regular basis?
So I'm going to be the person that it's kind of a kumbaya fest for so much of this. I'm gonna be a little bit maybe controversial. I don't think this bill goes very far when it comes to training, right? I think the issues that we've seen over the last few months, few years, are not going to be solved with training. We're not going to train our way out of murder. And we're going to have a much serious conversation about how we are going to fix this problem. There are certainly some good things in this bill when it comes to policing. I like the idea that there's a ban on destruction of records in this bill, right? That's a good thing. There is a ban on retaliation, right? If you're a quote unquote good apple, you can't be retaliated against, bad apples. But let's not make any bones about it, right? We have to have a much more serious conversation about police violence and police accountability. And while there are some steps forward in this bill, do not expect, and there's some things in this bill that start before 2023. Do not expect those things to fix the Adam Taleo situations and to fix insert name here.
Let me ask you this. Are they going to change the training of police officers from shooting body masks to eliminate the threat, a perceived threat?
There's nothing there about discharging of weapons, no.
Nothing, okay. This entire law will not take effect till 2023, is that right?
No, not the entire law. So when we talk about 2023, we are mainly talking about the end of money bond. So the end of money bond will end at January 1st, 2023. Remember that this bill is much bigger than money bond, though. There are probably 27 to 28 different things that are handled in this bill. And I have like a long Excel spreadsheet that goes over the kind of different effective dates, right? So for instance, the body camera piece, right? Depending upon the size of your jurisdiction, the requirements of when you have to put body cameras in goes from 2022 to 2025. There are some things that start in 2022, some things that start 2023, some things actually start in July. So, but the 2023.
What starts 2021?
There are some things around how we use electronic monitoring that starts in 2021. There are some policing things that start in 2021. I can pull out my Excel spreadsheet. It's like 1,000 lines long.
We're gonna have to have y'all back to go through what starts this
But the
year.
money bond stuff, the stuff that we're talking about, that stuff, the end of money bond starts January 1st, 2023.
Okay, so for 2021, we want to look at what starts now, because we are all excited about a law that we don't know what it does. I know more now than I knew before, and I'm sure everyone else, the way these questions are coming. Does it talk anything about use of lethal force? Does it talk anything about use of tasers in the training protocols for police officers? Since we know that some people can't tell the difference between a taser and a gun. I couldn't resist.
There is a change to the use of force standard.
Okay.
And there are prohibitions on certain types of above the shoulder restraints. There's also a duty to intervene, right? So if you're an officer and you see someone standing by, I believe I can look it up. I believe some of those things start a little bit earlier. If you give me a second to dig into my email, I can tell you when those start.
Well, I have all of you lawyers on here. We need to talk about are there any changes with respect to search warrants? Would the situation with Ms. Anjanette Young have been different based on this law being passed?
Yeah, there is something on no-knock warrants. We basically the bill adds a protected step, basically saying that a search warrant has to be signed by a supervisor, and that the officers must be wearing body cameras during the search, and they must make plans if there's an indication that there are going to be children or other vulnerable people at the site that's going to be searched.
I'm supposed to remind everyone that's viewing, you have to put your questions in the Q&A. The chat is disabled, so you have to submit your questions. Some of the questions we've had, you repeating the same question, they've already been asked and answered. I think this is really a great session. You all are giving us some tremendous insight into this law. They really are focused on these judges. We should have had a judge on here. We should have had Judge Evans to talk about the judicial training protocols. So as we prepare, I mean, how much more time do we have? I think we have 30 more minutes. We have 10 more minutes, 15 more minutes, 15 more minutes. So tell me, each of you, and we're gonna go to the attorney, the silent attorney on the, he's not silent, Attorney John Mackey. What else do we need to know about this law from your perspective?
Yeah, one of the things, I mean, it's understandable that the policing, especially given current events, has gotten a lot of attention. This bill also, along with my organization, we sponsored the reform to creditor compensation. We also worked with the Department of Correction to do a pretty substantial modernization of programming credits. Basically, in Illinois, we've really almost only constrained the ability of the Department of Corrections to reward people for good behavior, to reward people for taking, classes, things that would make them less likely to reoffend when they're released. So we significantly expanded that.
In this law?
In this law, yeah, it's gotten very little. I think in a normal year, that credit expansion would have been really big news. It would have been very hard. As it was, I think it just was able to kind of sneak in behind the other stuff. But it's definitely.
So what does that mean? People can take college courses or what? When you say credit,
it's just having more ways to earn time off their sentences.
Oh,
so
good time off, good time.
Good
credit.
time, yes. I think one of the big things is, so for example, Illinois has in statute an ability that authorizes Department of Correction to give time off for taking part in various kind of like educational programs, vocational programs, which is amazing, which is great. Research shows that's a great way to reduce recidivism. The problem is these programs, these laws have not been updated for 30 years. And so there are programs that look good on the books that just really aren't offered anymore. So we made sure those were updated to kind of that would reflect DOC's current programming. And so there's some, again, really substantial reform there. Probably the most substantial program reform the state's ever seen. This will make Illinois safer. It'll make our prisons less crowded. It'll reduce recidivism. And we also worked really closely with the Department of Corrections. So we worked really kind of almost hand in glove with them to make sure they were reforms that they could implement.
Oh, here's a question for all the state's attorneys. Here, this is interesting. How many additional state's attorneys and public defenders do you anticipate will be needed to review and redact body camera evidence? For example, is there any number of state's attorneys is there a relationship between the number of state's attorneys assigned to police districts and the number of body cameras?
I feel like someone from my office sent that question because the reality that I think we do talk a lot about body cameras. It is labor intensive to go through these body cameras. And so oftentimes when people are shown, unfortunately, far too many times in recent memory, these body camera footage, you may see a 15, 20 second clip. Right. Oftentimes there are hours of footage that you have to get through to get to that clip, to get to the circumstances before and beyond. And so it is incredibly labor intensive to sit and go through body cameras. We have a unit within our office called our Felony Review Unit. We also have a unit within our office called our Lead Law Enforcement Accountability Division that is specifically tasked with looking at officer involved shootings who, sit through and go through these videos for a while. And so there is, I think one of the reasons that Public Defender Mitchell mentioned, particularly around body-worn cameras, that the implementation dates vary depending on the size of your jurisdiction. There is a cost associated to having the equipment available to stations. And there is, a cost that we haven't talked about that, whether it's public defenders and state's attorneys who also, they have a right to the video as well, and they have to go through the video as well, associated with going through this new element of evidence. And so I don't have a fixed dollar amount. What I can say is that it does take a tremendous amount of resources depending on how much of this evidence that you have to cull through it. And certainly, especially with the increased use of body-worn cameras over the last several years, has shown, not even just in the courtroom, just in the preparation stage and determination of charging stages, we have needed more assistance doing that work than we had before.
Wow. Well, the other question I have is, does this law require a revision of hiring, promotion practices and processes for officers? Does this law in any way impact how officers are promoted from beat officers on the street to sergeant to captain?
I don't think so. No, I don't think so. Somebody can correct me if I'm wrong, maybe Mr. Mitchell or Sharone. But I don't think there's anything too specific about that. But certainly that's always an area that on the community level we have to be looking at.
The closest thing to it is that it does empower the Attorney General, and John Mackey talked about the Attorney General, Kwame Raoul. It empowers Attorney Raoul to commence these pattern and practice lawsuits. So if you have kind of a jurisdiction that seems like there's a lot going on, the Attorney General can go in and has expanded powers to try to see what's happening. But there are no specific mandates around who gets hired and who doesn't.
And it does also expand Reverend Wilson, you asked us about what we like about the bill that we hadn't talked about yet. It does also expand access to the officer misconduct database. It's a small amendment, but I think it's an important one. It does allow state's attorneys and additional sort of civilian personnel access to the database, which is really important. The chiefs are our partners, but there can be transitions. There can be transitions between chiefs of police. There can be disagreements between chiefs of police and civilian officials. And so there's that additional access for state's attorneys and other civilians is really important for that database. It's also the types of offenses actually that will put you on the database actually expanded again in kind of a small way, but there was once kind of a high floor to get onto that database. I think you had to commit a Class 2 felony, and that's kind of a high to middling felony. And now I believe someone can correct me if I'm wrong, but I believe any felony will get you onto the database now. So
somebody is very concerned about budget and personnel requirements. This law.
Sharone keeps asking that question somehow.
I know he's texting me. I can feel it. But so the question is, how does this impact our the number of staff people required for the judges, the state's attorney, the cook, the public defender, and now we know that the other agency that's involved is the Attorney General's office. Is that going to require an increase in staffing for all of these agencies? So it will increase costs somewhat. And I'm not asking what the cost is.
I'm waiting for Attorney Mitchell to make his pitch to the county board for additional resources, as he should.
Yeah,
but
he should.
as he should. I mean, we have to remember the counties vary across the state. And so one of the things that, we haven't talked about is that the Cook County jail population has decreased by almost 40% over the last 6 years or so. And so the question is, as we implement, the Safety Act and do bail reform, is there going to be further reductions? And if that's the case, some of the costs that we were carrying to maintain a jail of 11,000 people that gets down to 5, how is that reabsorbed into other areas? And so I think one of the things that when you look at resource reallocation as a result of these types of policy changes are really significant. Instead of first going to what is the new need, what are the impacted savings that you may have to be able to reinvest into other parts of the system. And so that's one of the things that I think we will be looking at. And I think one of the frustrations that many folks in the community have had for all of the efforts that we've done around bail reform in Cook County and has shrunk some of the population, not seeing those dollars reinvested into other aspects of the system, almost maintaining the same budgetary amounts as when we had almost twice the size. So I think the component of this, of making sure, and I will say it so to tee it up for Public Defender Mitchell, a healthy and robust criminal justice system has a well-funded prosecutor's office and an equally well-funded public defense. That people are entitled. It is not and should not be customary that we have one office that is funded at a rate different than public defenders. And so while we have had our own budgetary issues, I have always in my tenure advocated that the public defender's office has the money and the resources that they need.
Well, I was going to raise that because they have a higher caseload. They have a limited, fewer number of investigators, and the resources should be equal. Because what you're doing is punishing indigent people by not allocating and this happens all across the country, it's not just in Cook County, not giving the public defender the kind of resources and staff support they need, the office needs in order to fully and adequately represent indigent defendants.
Yeah, I'm so excited to have all these allies. I'm going to be asking you guys to write a report and send to the county board. I think you guys have said it better than me. Public defenders not only, it can be a cost savings, right? We spend an incredible amount of money incarcerating folks, whether we're talking about jail or whether we're talking about prison, and a well-funded public defender's office can reduce some of those costs, allow us to do our jobs better. But, we can talk about dollars and cents. We also need to be talking about humanity, right? The vast majority of people in this system are poor. The vast majority of people in the system are Black and brown. And we have to constantly think about how are we going to provide folks what they need? Is it fair for folks to not have the representation that they deserve? And I'm so excited to make this case to the county board. We do a great job, but we do it kind of on, shoestring budget. And yeah, so I'll shut up.
Well, you let us know when you're going to speak before the county board, because there are a whole number of organizations that will support your request. The other thing, no question about it. The other thing we need to talk about as we prepare to close, get your 60-second closing. All you lawyers know how to do a closing. You've done your opening, you've argued your cases, so now we're going to get ready to close. I really thank you for all of this insight and information. How do we, as we look at this law, we know that there have to be some other things that are done that really address the abuse of force by police officers. Will this law in any way address the issue of an officer like Van Dyke found guilty, sentenced? We know it doesn't address qualified immunity, but does it prevent that bad cop from working at another police station in another district?
Yeah, so one of the good parts of the bill, I know that in the legislative process, and as State's Attorney Fox said, so many of these things were years in the making. Our discussion about body cameras has been going on for a decade. In 2015, we debated body cameras, and nobody should have been surprised that there was a request to require body cameras. But this bill This bill does have a decertification process, which I know was primarily through the work of Attorney General Raul. And that bill sort of got put with this bill, but both bills had been worked on for a long time. But luckily we had everything come together at once, which I know is easier legislatively and for the governor. And so that portion of the bill does have a decertification process where officers who have committed misconduct, it is easier to decertify them so that they cannot be hired somewhere else. Expanding the misconduct database, in my mind, is critical to that also. In addition to the decertification, there are also penalties if officers lie in police reports, or if they in some way intend to hide evidence through the body camera, or through not using the body camera correctly. There's an intent part of that. I know people are worried about that. But there can't be accidents when you put in the statute that a prosecutor like myself or Ms. Fox would have to show intent. That's hard to prove. That's okay. But what the law is saying is, if you do have those cases where you can prove it through admissions, through somebody else, through texting somebody else, through circumstantial evidence, if you prove the intent, then those officers have tried to hide evidence, and they should be prosecuted. If it's an accident, it's an accident. It's not going to be prosecuted. So there are a lot of things that I think start us down that road of increased police accountability. There's so much more work to do.
Okay, each of you get your closing arguments. I want to thank each of you. This has been a very informative session. I'm going to ask the presenters and the co-sponsors. We have to do another session if you all are willing, not next week. But I think that over the summer, after you've had no vacation, you can come back and share with us again, because I think this kind of dialogue is just too essential. Most people don't know what you know and what you've told us. And the next time, I really would like to talk about each of your offices, each of your positions, and kind of some of the things that you do. One of the laws that I'm concerned about with as it relates to police is this whole a fleeing suspect. You know, what the law says about that. I'm running from you. I've not pointed a weapon at you. I'm in fear of police. What does the law say? It has nothing to do with this law, this particular law. But many innocent people are shot down really because they have this inherent fear of police based on what they have experienced, especially Black and brown males relating to the police officers. So in the future one, we can talk about that. Who wants to go first? Raise your hand. Okay, well, I'll call on you, Mr. Mackey, Attorney Mackey.
Well, again, thank you so much for having me. Just a deep honor to be with such amazing public servants. And I think the thing I want to leave people with is kind of to echo what Public Defender Mitchell talked about, is the humanity of this. And I think that's really what's super important about the crime victim compensation reforms, that ultimately, you know, we talk a lot about needing to reimagine public safety, but I think also at a deeper level, we need to reimagine government, and we need a government that can be there for people's absolute worst moments, you know, when they've lost their child to violence, for example. And we have now the law that will help us do a better job at that, but ultimately it's going to require implementation. It's going to require government working in a different way with community to establish trusting relationships. And then we're going to learn more about, you know, what needs to be done. So I'm really excited for that work. Really a great panel, and I'll close there.
Thank you so much. State's Attorney RINEHART.
This was a great conversation. I want to thank everyone again for their time and for their interest. We had a huge audience tonight, and that's just fantastic. It shows that people really are interested in this, and they're interested in getting to the truth about this. And I think that people wanted to hear us out and learn more about the bill. That I'd encourage everybody to read the bill and to read summaries of the bill that you trust and try to understand who's giving you information, and does the person who's giving you any information have a bias in it. As Mr. Mackey and Sharone said, this bill is supported by victims groups. This bill is supported by domestic violence survivors. And so if I guess I would want to arm allies of this bill with this argument. If anybody's telling you that this bill isn't helping victims and survivors, then just ask that person why the professionals, why the historical groups believe in this bill. They believe in this bill because it makes us safer. I think that what's at the heart of this bill and what's at the heart of having new reform prosecutors in office and reformers like Sharone and Mr. Mackey working so hard is that at the end of the day, fairness and safety are not in conflict or should not be in conflict in our criminal justice system, and that we can be safe, and also be fair to people and also hold officers who make mistakes accountable. We can achieve all these things. We just have to aim for that, and we have to be intentional about it. And I think that's why this bill is so amazing. So thanks everyone for your time tonight, and thanks for listening.
Thank you for your time and for your service. Attorney Sharone Mitchell, the only public defender on this call.
Yeah, I'm so excited about, I with the Coalition to End Money Bond, the Illinois Network for Pretrial Justice, got a chance to work on the bond sections of this bill. And I'm so proud that this was a section of the bill that was inspired by grassroots organizing. It was people taking to the streets, both nationally, but people also taking to Springfield, having lobby days, and really spending the time and telling the story about why attacks on Black women isn't right, why putting people in jail just because they're poor isn't right. This was an incredible movement that we were able to accomplish, and I'm so excited about that.
Thank you. Go ahead.
Almost done. Closing almost done. That's my first half. This is the second part.
I know you got a three-part close. Go ahead.
2-part close. Listen, we are being told constantly in the news that if judges judge a little bit harder or prosecutors prosecute a little harder, that we be safe. And we've been told that for decade after decade after decade after decade. We are not going to solve the problems that we have in our community, and they're real problems with harm, unless we're serious about the root causes of that harm, unless we're serious about economic inequality, unless we're serious about our community being awash with both trauma and guns, and where those guns actually come from. We are not going to solve this problem by sending people to prison just a little bit longer. It's not going to happen. We have to get real. The real racism isn't just like the policing. It's our just reliance on broken solutions. I come from born in South Shore, raised in West Pullman. It's not working. It's got to be different. And we need leaders that are willing to look at this thing in a different way if we actually want to be safe. Thank you.
Boy, you all really do close, and you have gotten Jan so excited. She doesn't know what to do. And the state's attorney for the largest county in the state of Illinois, and I think you're probably the third largest county in the United States, second largest in the United States. Attorney Fox, you get the last closing.
Well, again, I too want to thank you and the sponsors for putting this event together, and really an incredible panel who, like I said, aren't new to this, they're true to this, and have met the moment with the movement. I just want to, piggyback off what PD Mitchell just said. I think in the coming months and what we've seen, not just historically over the last several years, but it's really been ramping up this narrative that is based on fear. And the reality is that, yeah, we are in really difficult times right now. The violence in our communities has been rising in the last year or so. We are in a historic moment, a global pandemic, national a civil rights movement related to policing, an economic downturn. This is unlike any period in any of our lives. And we have seen, some of the results of that has manifested itself dishearteningly in violence in our communities. But that does not take away from the fact that the work that has been done for years around these reform efforts have been rooted not just in stories, but in data. And the data and the facts have told us that where we are with justice reform is on the right track. That the practices of the past did not keep us safer. Over policing and over prosecution and the push towards over incarceration didn't make our communities safer. That some of these same neighborhoods that are struggling with violence this year are the same neighborhoods that were struggling with violence 20 years ago, that have not been economically invested in, that still have under-resourced schools, that have young people living with the trauma of violence that they have seen generationally. And so what we also have seen is that the overuse of our criminal legal system has further exacerbated that trauma as well. And so what I want us to do is brace ourselves that even when we get tough headlines, the instinct of saying that we've gone too far, we've done too much on a bill that's not yet even implemented, where we are ready to throw it out because and I've heard it. I will be honest. I hear all the time. She's too much reform. This system has been fundamentally broken for far too long. That these efforts to fix it are going to take time to take root, but we do not abandon it because there are those who profit from headlines that are of fear. There are those that profit from, advertising for people to turn on the news out of fear. It is understandable where we are, but to abandon these efforts because you've seen a headline, because you've seen the story of the person who was out on bail. I hear all the time, well, that person was out. They don't talk about the thousands of other people who have been out and not committed a crime. They don't talk about the thousands of other people who have been able to be in their communities and care for their families and live their lives without picking up a new crime. And so when you hear the story of the one, I'm going to ask you to root yourselves in what are the stories that have not been told. And when someone is telling you that we've done too much too fast, ask yourself, how long must we wait? How much small incremental change are we willing to commit ourselves to fix a century broken system? Or how do we owe it to our future generations to meet the urgency of the moment now, and to be bold, to be visionary, and to accept the moment where we are to do big, great things, because that is what history has laid before us right now. So I'm honored to be a part of this for the advocates and activists who worked on this bill for years, where I had the pleasure of testifying down in Springfield 3 years ago on this, to see this come to fruition, to take our time to get it right. My last parting words to all of you is, do not let those who fearmonger, who seek to go to the angels of doubt, steer us from this path, because we're on the right path. We are blazing a trail, not just here in Illinois, but for the rest of the country. And for that, we should be incredibly proud.
I want to thank each one of you. This has been perhaps one of the best discussions, legal discussions that I have participated in over time. I mean, you've been very forthright, very honest, very transparent about this particular law. And I guess it's because all of you have been working in the trenches over the years, fighting for a transformation in our criminal justice system. What I get from all of this is we have to deconstruct, not eliminate, but deconstruct the system. And that means to assess it, evaluate its strengths and its weaknesses, and make the appropriate adjustments to the system so that it works for everyone. And to see each of you having worked with different organizations fighting for justice in this system, and listening to how you have had some impact in this particular law, but also recognizing the flaws in the existing criminal justice laws that that you're forced to use to implement, to support as prosecutors, or to defend your client if you're the public defender, or if you're like the NAACP and Rainbow Push and NOW and League of Women Voters and the National Council of Jewish Women, having to deal with the people in the community, or with the Innovation Alliance for Safety, the Alliance for Safety, having to look at the victims and talk to the victims and struggle with them as they try to understand some of these laws. I am so impressed with your commitment, your struggle for justice and equity, and the fact that you have spent this time with us tonight. I want to thank all of those who are viewing on Zoom, that are watching us live on Facebook and YouTube. Thank you for your patience with us tonight. I hope that we've answered many of your questions. I know you're going to have others. You can contact us at Rainbow Push, or you can contact any one of the sponsoring organizations. You can contact Jan Schwartz. We want to thank you so much who pushed to make this happen. We want to thank Betty Magnus, who has been texting us all night long to make sure that this was a successful forum. We want to thank Alana Ford and Rose Glenn. Alana pushed this out in social media through all of our networks. Rose Glenn is making sure that the technical aspects of this. And we want to thank Patrick, representing the NAACP, Patrick Watson, the DuPage County NAACP. We thank you for all of your work. Wave your hand, Patrick, so they know you're here. There you go. And each of the organizations, Chicago Women Take Action, NAACP, DuPage County, Rainbow Push Coalition, Plus 44, co-sponsors that are on the screen. We could not have done it without each one of you. And we're going to do this again. As Reverend Jackson would say, we're going to do this very soon. And we're going to invite all of you to join us as we look at some of these legal issues. Attorney Fox and Attorney RINEHART and Attorney Mitchell, and the one that wouldn't tell me he was an Attorney Mackey. Our convention is June 19th through June 24th, and we'll be talking to you about the legal component. We're going to have a women's roundtable, Attorney Fox. We got to really look at issues. And we'll have a multicultural session as well. I want all of you to join us. June, it's going to be virtual, so you don't have to drive anywhere. You don't have to go anywhere, just like we're doing now. We want to make sure that you are engaged. With your permission, we'd like to re-air this program again, in part on our Saturday broadcast, because I think this is just information that people really need. Thank you, thank you, thank you. Please put your information in the chat if Rose does not already have it, so we can stay in touch. Thank you again, Jan. You can calm down now, it's over.